All right, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we're going to talk about criminal law, which is obviously a favorite of mine here. And we are joined by Jessica Zita, who is an associate at Locklear Posner Craig, formerly known as Locklear Campbell Posner. So, congratulations there to the change there. And maybe you can tell us a little bit about it, Jessica. And certainly, we're very happy to have you on here today and talking about criminal law. Maybe you can start by telling us a little bit about yourself, your practice, how you got into criminal law, and it's great to have you again.
Thanks, John Paul, and hi, everyone. So just to address the firm name change, Campbell, when he used to be Lockyer Campbell Posner, he was recently appointed to be a judge of the Toronto Superior Court. So we will miss him dearly, but it's a great win for the justice system because he's going to be incredible. And so because now he's a judge, the firm name has to change. That explains that. Now, for me, how did I get into this crazy world? I guess it goes back to 2010, probably a very long time ago for a lot of you here. I graduated from university. I went to the University of Toronto. I studied political science and I did a minor in French language studies. And I graduated. I wasn't sure what I wanted to do, but I had this ridiculous belief that I want or desire to change the world, whatever that meant at the time. But I had an even more overwhelming need to pay my debt. So I had to get a job in the real world. And I started applying and I found a place. One of the posts that I responded to was looking for two criminal defense lawyers who had went off on their own, and they were looking for someone to help them manage their office. And the posting was very scant. There wasn't a lot of description. It was like one line. There was mention of having, being proficient with technology and using a photocopier. So I felt that I was qualified for such a task, and I responded. And I met with who ended up becoming my mentor, a man named Alex Esmont, and he hired me. The job ended up being a bit more than what the post had read. I had to basically help them build their office from scratch. Included setting up the phone lines, creating file management systems and softwares, and like I had to back up all the documents. I had to create like some sort of all these spreadsheets. I was even doing their accounting. It ended up being 3 lawyers, and I was they were working in an association, which means that they were running 3 separate offices rather than one as a partnership. So I was essentially I had 3 different jobs really in one office. And by the end of it all, I was doing everything short of actual lawyering. I was going to court as an agent. I was speaking to cases in court. I was handling all the clients. I was scheduling meetings with Crown attorneys, and it really opened my eyes to the criminal justice system, procedurally especially. It gave me a huge look into it, and I realized, like, rather than saving the world, like, our world at home needed help. And it gave me firsthand experience into the community and what our community needed or what it really lacked. And I had a knack for it. I had never really, I did okay in school, but I was kind of lazy because I was not too inspired. And it was the first thing in my life that really inspired me, really pushed me, became just obsessed with it. So I worked there for about 3.5 years. And I call Alex would be my mentor because he was really an important force in getting me into law school or encouraging me to apply. I don't know that I would have if not for him. And so I did, and I got in, and I ended up, after my first year, I applied for a second year summer job because that's typically how it goes when you're in law school. I went to Osgoode Hall, and in my second year summer, I was hired by a firm called Hicks Adams, which is probably one of the larger criminal defense firms in Toronto. So I was hired there as a summer student. They hired me back as an articling student. I articled there. Do you want me to keep going until today's date?
Sure. I mean, the next question would have been like, well, what happened after law school? But you might as well keep going then on that front after after or leading into articling.
Okay. So I guess for anyone who doesn't know, articling is sort of like an apprenticeship you have to do after law school. The Law Society requires that you work under the supervision of a lawyer who qualifies as a principal by the Law Society. That lawyer has to supervise you during your articles, where you do assignments and all kinds of work for them. And at the end of your articles, if you've done a good job, the lawyer will give their support. They will endorse you to the Law Society, and then you get called to the bar. And being called to the bar is essentially being made a lawyer, being licensed as a lawyer by the Law Society. So I articled, and I had a very enriching articling experience. I knew right from the get-go of my articles that this is my calling. I worked very hard and very relentlessly, and it didn't really feel like a job, but it was tough. In my articles, I got experience doing homicide. I was somehow, as a student, involved in a homicide trial. I also developed an interest in appeals. One of the lawyers at the firm I was working at, his name is Richard Lakowski, and he is very well known, a very accomplished appellate lawyer. So I sort of tricked him into taking me under his wing. I got appellate experience in law school. I did an internship at the Crown's office. It was the appeal Crown's office, which is different than trial Crown. And I did that for about 4 months. I also, in my first year summer, I worked at the Court of Appeal in Michigan, or the Sixth Circuit Court of Appeal in the US. And that also sort of availed me to the world of appeals. So most people, like, law school doesn't really prepare you for those sorts of different roles in the criminal justice system. So I was very fortunate in that sense to get that experience. It really allowed me to see different sides of criminal law that a lot of people of my vintage don't know exist until maybe it's a little too late. So after my articles, I was hired back by Hicks Adams as an associate, and my main role was to work as an appellate junior associate with Richard Lakowski, and that's how I got most of my experience doing appeals. Just hit the ground running, and I started off doing a lot of appeals and a lot of homicide trials with Chris Hicks, the partner of the firm. And after a couple of years, it was 4 years of doing that, or 3.5, I took a job offer with Lockyer Campbell Posner. And to any of you who know, James Lockyer is basically famous. Maybe no one knows who he is here, but he's kind of the king of wrongful convictions work in Canada. He's a founding father of Innocence Canada. And he's done a lot of work in that field. He's done a lot of incredible work. He's won an Order of Canada. So the opportunity to work with him is a dream for anyone who's interested in appeals. And I started that position in November of last year and been doing that ever since.
Perfect. Thank you so much, Jessica, for sharing all of that and your journey to where you are today. So is it predominantly then, I know you know a lot of your experience there is on appeals and homicides there. So is that predominantly what you're doing at the firm today, or are you kind of still doing a little mix of some trial work as an associate there?
So I do have a mixed practice. Appeals are something I'm very passionate about, and I think I'm quite knowledgeable in. But I don't know if unbeknownst to many, I have a pretty thriving is too strong of a word. I have a not small trial practice. I feel very fortunate to have that, and it also it's good to, I find as a lawyer, it's good to have an experience in both, because your appeals, having experience doing appeals makes you a better trial lawyer, and having experience doing trials helps inform your sense about a case when you're preparing for an appeal. So I try to keep my hand in both pots as much as possible. So yes, today in my practice, I would say is 60, this is really approximate, but I guess 60% appeals and 40% trials.
All right, so maybe we can start with that, and then we can maybe work to the beginning of a trial matter and take it all the way to where it gets to an appeal. What's the fundamental difference, I think, when you're talking to students here or young practitioners about getting into appeal work? What's the most important distinction there when you're getting an appeal, wherever it's going, let's say to the Court of Appeal or to even a summary conviction matter going to the Superior Court? What's fundamentally different about preparing for that versus preparing for a matter that may go to trial?
Two things: the speed at which a matter goes to trial versus an appeal, and the preparation, including writing. Many trial cases are almost entirely happening in court. They're litigated very quickly. So a lot of court work, not so much writing. Unless you're doing a super serious case, it's not very often you're going to have to submit written materials. And they move really quickly. Sometimes they resolve, sometimes the trials are one day. It's very quick turnaround. Whereas an appeal, most appeals take years from beginning to end. And when I say beginning, I mean from the filing of a notice of appeal advising the Court of Appeal or a reviewing court that you wish to appeal, to the end, which is a final decision from that court about the success of your appeal. And when you're preparing for an appeal, the preparation for an appeal is almost entirely reviewing the transcript from the trial level. And that's a lot of reading. And then once you've reviewed that transcript, you have to write what's called a factum, which is written submissions. The Court of Appeal, there's a limit of 30 pages, and you have to summarize the transcripts, and then you have to write what the legal issues are. So it's always a very academic exercise. And you, compared to the amount of work you put into an appeal, you have very little limelight. Whereas limelight meaning you're in court for maybe a couple of hours, years after preparing, really starting preparation for this appeal. Whereas a trial, you are in court the entire time. And the preparation is just different. It's quicker. You're on your feet more. You have to make more on-the-spot decisions, where an appeal is just a far more academic exercise.
Perfect. So let's maybe go to on the 40% side of your practice here, the trial practice for my paralegal students who've been kind of going through and they're leading up to their exam tomorrow, and anyone certainly listening later on can go through this the same way. Let's start from the very beginning. So you get a call, whether it was at previously where a client or a potential client calls up the firm and says, "Hey, Jessica, I'm in 14 division in Toronto. I've been arrested for an assault. What do I do?" Right? They're going to hold me tomorrow for bail. What is this bail? What's going to happen? And I know obviously the process, maybe you can touch on this a little bit, is different now that things are done over the phone and remotely, as opposed to whereas before they would be shuttled off to Old City Hall or College Park or wherever. So maybe you can tell a little bit about that arrest and what's important to tell a client, and maybe getting into the bail process.
Okay, so once a client's arrested, I mean, arrest can happen. Normally, it happens one of two ways. They're caught doing something on the spot that police are now considered illegal, or they've been under investigation and police are executing a warrant in their arrest, like an arrest warrant. So when they call me, I tend to, first of all, you always tell them, don't say anything. Don't talk, don't, everything you can say at this point can be used can and will be used against you. And then I just tell them, I get as much information with respect to like where they're going to be held. They're going to be held for bail. If they're going to be held for bail, do they have anyone who's available to come forward to support them, offer support in their bail, otherwise known as a surety? Have they been told of what the exact charges are? And then, other things that I need to know to secure my involvement in the file. Following that, procedurally speaking, officers have to swear what's called an information. And an information is a charging document that is filed with the court. And it's what keeps the case alive in a courthouse. So anytime the case is in court, the information is going to be before either this document is going to be before either the justice of the peace or the judge. And the information will say what the charges are when it's alleged that these offenses occurred, where they occurred. And then there's places to write in the next court dates. So procedurally, that's sort of the first bit in the process. Following that, legal or an accused person has to be brought before a court within 24 hours of their arrest. So they get brought to court, they can be released, or we have to have a contested bail hearing. But regardless, they have to appear before a court and give instruction as to whether they're going to address bail or hold off on it a bit and figure things out. Then, it can go in a couple different ways. If they are going to have bail, we have a bail hearing. Either they're released on a release order, or they're detained, meaning detention is ordered, and they remain in custody throughout the rest of their case. The next step in the process, once bail has been thought about or dealt with or decided upon, is disclosure. What disclosure is, it's the Crown's evidence. So in every criminal case, the police have to have reasonable and probable grounds to arrest. Once they feel they've met that threshold, they arrest, and then the case becomes goes to the purview of the Crown Attorney's Office. And then the Crown decides whether to prosecute, and in most times, how they're going to prosecute. So once the Crown is made the decision on whether to prosecute this case, they'll pull together disclosure that's brought together by an officer that's investigating the case. And then that disclosure under the law has to be produced to defense counsel. Defense counsel gets this disclosure, reviews it with the accused, their client, and then decisions are made on what to do next. And the decisions are one of two things. You're going to go to trial, or are you going to, is this something for which you can plead guilty? And those are very tough questions to ask. That's a huge simplification of the process because, John Paul, as you probably know, sometimes these charges are very serious, like murder. Sometimes they're nothing, they're theft under. So sometimes the choices in that are a little more complicated. Like, are you going to have a preliminary hearing? Are you going to go to Superior Court and have the trial? Or are you going to have it at the Ontario Court of Justice? But the umbrella idea is the question at this point is, once you receive the disclosure, is where are we going to go with this? Sometimes it's not always clear. Sometimes disclosure is missing, or the Crown has not provided something that they should have. Sometimes the disclosure will say that there's this piece of evidence that you don't have yet. It's always the Crown's burden to prove guilt. And so that's the number one thought to have a defense counsel has in their head when reviewing a case with their client. But that's sort of the idea at the infancy of the process. So I guess the next major milestone in a criminal case is whether is resolution or the actual trial. I guess I'll start with resolution because it ends quicker than a trial. If your client or if an accused person has decided that resolution is in their best interest, there's a number of reasons why. I'm not going to get into them. If you want, if you want me to, I can. But just briefly, some of the reasons might be that the going to trial, that if they lose, it'll be worse. If they're convicted, they might come to a resolution with defense might strike a resolution with the Crown that is preferable for the accused, and it's just in line with what they want, and they just want to get it over with. The bottom line is, though, they have to be able to accept guilt and admit to the facts. However you come to that there's multiple ways, but if you've arrived at that and that's where you're at, an accused person will plead guilty in court, and then they'll be sentenced. The sentence can either be an agreement between defense and Crown Counsel, otherwise known as a joint submission, or you could have two different positions, and it'll be up to the judge to decide. That will end that process. Should an accused person decide to go to trial, they'll go to the first date of the trial or the date of the trial. They'll be arraigned. There's the arraignment process, which is the reading of the charge. And after arraignment, an accused person will almost always plead not guilty at a trial. Sometimes they'll enter a plea to a lesser included offense. So, for example, say you're on trial for first-degree murder, you may want to enter a plea to manslaughter. So you're indicating to the trier of fact that, or the jury at this point, that I'm not guilty of this, but I will concede that this was a death caused by my action, but I had no intention whatsoever. It was a complete accident. The trial will begin. If it's a jury trial, you'll have to just choose the jury. So the jury will have to be chosen. If it's a judge alone trial, you'll just start the trial before the judge. Sometimes there's pretrial motions where you have to discuss evidentiary issues. But if you are just going into the trial itself, the Crown will call all its evidence first, then defense will call its case, and sometimes an accused person never has to testify, but sometimes they might. Sometimes there might be other witnesses, all very case by case. And then the judge or the jury will render a verdict. If acquitted, that's it. The case is done. If they're found guilty, we move to sentencing, and then same thing. It might be a joint submission. It might be open. Once sentencing is done, once the accused person is finally sentenced, that triggers the appeal process. And only then can the appeal process begin. Within 30 days of being sentenced, an offender now has an automatic right to appeal if they've been convicted, and they file their notice of appeal with the Court of Appeal, whether it's the Superior Court of Justice in the summary conviction case, or the Ontario Court of Appeal when they've been charged with an indictable offense, or they've been convicted of an indictable offense. And filing the notice preserves the right to appeal. They retain their counsel, then they order the transcripts, and God, that can take a really long time, but eventually you get the transcripts, you review them, you write your factum, you submit the factum, you argue the appeal. Sometimes they'll be with, sometimes they'll agree with you, most times the court won't. Court of Appeal on appeal is made up of 3 judges, the panel. If they allow your appeal, great. If they don't, you have one more option. It's going to the Supreme Court. It's not automatic. You have to apply to be accepted. You have to apply to have your appeal accepted. It's very difficult to do that. Sometimes if one of the 3 judges doesn't agree at the Court of Appeal, you get automatic right away to the Supreme Court. But again, that's also very rare. Then if you are lucky enough to have your case heard at the Supreme Court, you either win or you lose. And then it can go a number of ways after that. But that's essentially the entirety of the criminal justice system in a nutshell. If you lose all of your appeals, but you are steadfastly innocent despite being found guilty, there's one more right It's called a 696 application or ministerial review. And this is how many wrongful convictions are argued. And you essentially go to the minister and say, there's been a miscarriage of justice. There's evidence here that exonerates me, that I haven't been able to deal with any of the appellate courts. Please look at this and review my conviction. And that's the final step in the process.
Perfect. So thanks kind of for giving us that overview there. It's great to cover the different pieces. Now I'm kind of going back to maybe looking at it from preparation, whether you want to look at it from an application, like a charter application, or at trial, or arguing the appeal. And then the question that I get often from students is, how do you get yourself comfortable, after, is it just something after many years of experience in terms of being up there on your feet and arguing, right? What gets you more relaxed and dealing with nerves and anxiety? What have you found in your experience to whichever aspect you want to look at in terms of delivering submissions or questioning witnesses in your practice?
That's a good question. I think most of the professionals I've worked with are always a bit nervous. And I think it's because it's just a respect for the court. And also our clients are facing a lot, so you want to do good by them. I'm always nervous, and I'm always preparing up until the last minute, whether or not I've been, you should always be well prepared, but I'm always reviewing up until my notes until the last minute. That said, I'm definitely more comfortable now in the court than I was when I first started. How you get to that, I think maybe it's different for everyone. Some people are just, born confident, like have that voice and believe and just sell everything they say and they believe it and that's it. Others, like myself, we're not that way. Experience has really helps in developing that confidence in that sense. Reading the law, watching others more senior litigate, working alongside them. And I think just being in court, getting as much experience on your feet as possible and going through as many, everything twists and turns. Nothing can be planned. There's always some new thing that's going to arise out of nowhere when you're in court. And it's just learning and getting the experience of dealing with all those curveballs. And at the same time, being as prepared as possible. The preparation cannot be overstated. It just makes a huge difference, and the court can tell. And I think the more you're before a court, the more credibility you get, and that also helps as well. But it's definitely being on your feet as much as possible.
Now, in terms of, certainly oral advocacy there, but what about, you're doing quite a lot of your time there on appeals, and even in preparing applications, there's a lot of the written advocacy. And again, a lot of students, when they're, whether it's completing an exam or an assignment, sometimes struggle with just the writing aspect in terms of how to craft, a really good, strong facta, let's say, about whatever the grounds of appeal might be, or the charter application, let's say if there was, I don't know, a Jordan delay or something. What can you share kind of from the written aspect? I think that sometimes gets a little bit more neglected from, you watch all these TV shows where they're all about advocacy on their feet, oral advocacy on their feet. But what can you share from writing so many different appeals and parts of it and applications that I think it's important for students to know in terms of skills to prepare and better themselves for potential futures in working in criminal law?
So I've been fortunate to work alongside some pretty accomplished legal writers, mainly Richard Lukowski and then James Locke here. And what I've learned from them editing my work and reviewing and then watching them write is being concise as possible. And often more is not better. I think being succinct, finding the balance between being succinct but offering as much detail as you can. That's sort of the sweet spot in legal writing. If it sounds complicated, it's probably wrong. I think getting to a place where you can break complicated thoughts, you can distill complicated ideas and thoughts down to like very simple, clear sentences is the best way to approach legal writing. And one of the big rules or unspoken rules is point first advocacy, meaning like what's your point, like state your point, the main line of thought here, and then develop it after, because it tells your reader where you're going, it's clear, and it provides a roadmap for what your argument looks like or is going to look like. And I think understanding your audience and writing for your audience is, while also, like I said, being as clear and concise as possible, are good measures to keep in mind when developing legal writing advocacy.
Yeah, that's always interesting because I think a lot of people, even when you go to the law school from undergrad, you're used to writing these really lengthy essays, and then to kind of switch gears now and say, well, you have to be more concise. It's sometimes difficult in finding what's the most important. So, and anything maybe further to expand on how, or even in an appeal, like you pick the most strongest ground and you don't bother with some of the, maybe there's a small error in law on another area, but do you mention it, or you just focus on like the strongest argument and you spend your time only focusing on that rather than trying to throw three things at the wall and hope one of them is convincing to the Court of Appeal or the Superior Court or wherever it's going to?
Everyone practices differently. I have been taught that you stick with your strongest arguments. You really shouldn't throw everything in the kitchen sink into the factum, because in my mind, you want to hold credibility with the court. And there could be a number of small little issues. But I think if you do enough of these, you'll recognize that in those small issues is one large issue. And all these smaller issues can be tied into that greater issue. It helps. I mean, this is all in line with being concise and clear. If you have 3 grounds of appeal, you can, I think, more effectively articulate the issues with those grounds rather than focusing on 10 grounds of appeal. You also have to hold the attention of the panel and the bench. And if you are just jumping around between little thinly articulated appeal grounds, you'll lose that attention. But if you really focus and develop on major grounds and maybe have subheadings with some of the smaller issues, that, in my experience, has been a more effective way in advocating on appeal. If there's a small issue that I find and I don't think it's enough to be put into a factum, I'll raise it in oral submission as an aside, sort of like as just something to add when I'm talking. And as long as you can point to something in the transcript, because you have to root every idea you raise back to something in the record, in the transcript of the trial. And as long as you can do that, and you can take the panel back there and you can go through it with them and you can substantiate your claim, that is one way to shout out to a small issue that maybe you realized too late or wasn't going to fit in your factum, but you think is interesting enough to raise on appeal.
And is that in terms of let's say the applications at the trial court, right? I mean, now they have, or something, they've always had the forms, the Form 1 for the application and the Form 2 for the response and so forth. Is that still something that you would kind of put Schedule A attached, or do you kind of find a way to be very concise and just use the I don't know, everyone's probably different on this, use just the boxes there that are provided for your notice of application if you're going to bring some kind of charter application at the trial level?
So it depends on the forum. If it's in the Ontario Court of Justice, I think it's encouraged you use the Form 1 and you just fill in the boxes. And if the application requires a factum, then Factum's obviously not done on a form. But in every application you have to bring a notice, which states the issue to the court and preserves your right to litigate that issue. And then maybe not all the time in the Ontario Court of Justice, but in the Superior Court of Justice, you also have to have a factum that really details the case and applies the issues and the law to the facts in that particular case. At the Ontario Court of Justice, it's not always required. Like I said, there's a lot of the trial work writing is not as much at the forefront as it is in more serious cases or in appellate advocacy. But you do need to use a Form 1, a streamlined form. And then in Superior Court, it's not that way. You do have to use create a notice of application, but there's always templates you can work off of. I think there might actually be a streamlined form at the Superior Court that you could use, but I don't think I've personally ever relied on that. I've just used my own, unless I'm helping a self-represented accused. Otherwise, I just use my own templates and then add a factum, and because you have to create a notice of application, an application record, which is a booklet of all these things plus what evidence you're going to rely on in support of your application. And then at the Court of Appeal, again, it depends on if you're a self-represented appellant, you do use a stream, like a pro forma form, like an inmate notice of appeal. If you are solicitor, like you're retained as a solicitor on record at the Court of Appeal, there is a template that you have to follow, but it's your own. It's not a form that you have to fill out.
Perfect. Now, I guess getting back to, well, maybe on the appeal side there, you mentioned before, obviously you're doing all this time preparing, and then in terms of maybe submissions, when you may get an hour or 2 hours or something, how do you find what to discuss? And certainly the other aspect there is you may be getting questions from the judges. So how do you kind of go from, we have all this in our record here, and we've created our facta, it's 30 pages. How do you get from those 30 pages to what I want to talk about? Do you just pick the best thing and start talking and be ready for questions, or what's kind of that strategy in transforming or taking from the written submissions and then going into what you want to highlight orally?
That's such a good question, because in almost every appeal I've ever prepared for, I always start off like when I begin to draft I write out all my submissions. That's maybe not what all lawyers do, but for me, that's part of my preparation. Like I like having almost a script of what I'm going to say. It makes me feel better. It's one of the ways like I feel more confident in court. But anytime I'm about to begin drafting my submissions, almost always I'm like, what am I going to say about this case that's different than what's in this factum? And what ends up happening 9 times out of 10 is, and again, this is different for everyone, but for me, I connect to cases. That's how I advocate best. And there's always like a theme that inspires me with each case that I work on. And when I'm drafting my submissions, I really think about that theme. And I start from that basis, like an opening line, like this appeal is about. And then I develop the script. The script will flow from there. And when I go through each ground, I think about what I can confidently speak about, like what I feel conversational, what I can express in a more conversational way for my factum, and try almost to like summarize the factum in a way that is would be orally interesting to other people. And in doing so, you have to, reading a factum out loud is boring. No one cares. So how do you make that interesting to you, the audience? How do I make that interesting to the panel? And that's what I really think about in drafting my submissions. What my bottom line is, what emotion do I want to express or explore? And the question I always ask myself is, what really troubles me about this? What is troubling? What needs to change? What is the issue here? What is just so offensive about what happened in this case, that I need this court to really listen to me and change the result because this cannot stand. And that sentiment underlies almost all of my oral submissions on appeal.
And what about the questions? Like, how do you anticipate questions? How do you get yourself? Do you write out potential questions and have the answers for them? What do you do for that?
So I try. Everyone tries, or everyone should try to anticipate questions that the panel might ask or the court might ask. There's always like weaknesses in the case. There's always soft spots where they'll push you on it because they want to see how you will respond to that and what you've come up with, or maybe there's something they don't know that's not apparent from the record that they're going to invite you to fill them in. They'll ask questions that communicate to you what's on their mind. So sometimes you'll be arguing a ground of appeal and they'll ask a question that indicates like they're not really interested in that ground, they're interested in this other ground. And so it's sort of your own roadmap from them that you go to that ground, you start talking about it. But in terms of questions, it's hard at first, but you sort of pick up the more you do this, what would intrigue someone. When you're appealing a conviction, it's always an uphill battle. And it's not something a court loves doing. It's really difficult to achieve. So you think about the questions they're going to ask that will make it easy for them to dismiss your appeal. And you try and come up with responses. But that being said, sometimes they just say things that take the wind out of your sails. And it's just learning what the strongest parts of your case are that you think are undeniable and sticking to them and finding different ways of saying that, while also being fluid. Being fluid and responding to them and to their questions is a very important skill. But as much as you can prepare, you really don't. The benefit of experience is nothing else. Everything else pales in comparison to the benefit of experience.
Now, one of the things there you shared certainly is that you're working on a lot of these cases, and certainly even all the way up to the wrongfully convicted. And there's so much at stake. And one of the things we've been talking with everyone, all areas of law here, is taking care of your mental health as well, and how you're able to deal with when you have so much, especially in criminal law. I mean, people's lives are literally hanging in the balance in terms of, they could be going to jail for a long period of time, or they could be found not guilty, or they could be successful on their appeal and they could be out of custody where they could have been for some years if they didn't get bail pending appeal, for example. How do you kind of find ways to balance all of that, given, especially, you've worked on homicide cases and stuff where they could be gone for the rest of their life behind bars, and understand what's at stake and still be able to be relaxed to an extent, and be able to go home and say, okay, well, I'm done work for the day, and I want to unwind and be ready to do this again tomorrow.
I think that's a very it depends on everyone's personal experiences and who they are, like their constitution as a person. For me, it's important that I listen to myself and I'm in tune with how I'm feeling. I think what really helps is I'm very inspired by the work. And as long as I'm inspired, I can dig deep to do what I need to do. But sometimes you do get tired, and sometimes you are not in a great mood. And it's okay to take a break, and the break doesn't have to be, there's a lot of pressure in this profession to go no matter what. And when you're starting out, I think it's harder to create boundaries, but it's really important. What I've learned early on is I can't help anyone, I can't save anyone's life if I'm not okay. And so creating those boundaries and creating a space for myself to just be calm and centered is very important for me to be effective as a lawyer. It also helps me at least to think clearly and really refine my judgment. I also, having support in your personal life is very helpful. Having someone to talk to, even talking to your colleagues, really helps too. It's surprising how many people it's not surprising. It's just shocking, actually, how many people feel the same way as you. But we're still dealing with like an old guard in the sense that some people feel it's not okay to admit what's weakness, even though I think admitting that it's not perfect all the time is a form of strength. It's really just a lot of this has to do with knowing yourself as both a person and an advocate, if they're one and the same, and knowing what your boundaries are and having the confidence to respect yourself. Because the sooner you learn, if you don't respect yourself, no one else will, the sooner you're better to protect your time and space and protect yourself as a professional.
Perfect. So Jessica, thank you so much for taking the time here and joining us and sharing about your practice and your journey, and certainly on the appeals there. I think not too much we get to cover that here for my students, at least, since it's an area that they can't really practice in. But so it's great for them to get that knowledge and learn more about our criminal justice system from so many different people. I was wondering if you have any final words of wisdom now, if you think back to maybe when you were in law school and what you know now compared to what you knew then and what you wanted to know, in terms of whether it's preparing for the articling or the OCI process for law students, or just in terms of making that jump from being a student to then being a practitioner. Anything you can share with my students as they hopefully look to get into careers maybe down the road in criminal law if they're interested.
Don't second guess your passion. I think in pursuing this line of work, it can be very tiring. And if you're passionate about it and you have a clear idea of what it is, what the work is that you want to do looks like, you have to pursue that. Don't listen to others. Do what feels right. It's important to be fearless, but it's also important to not be reckless. So finding that line is very important. And I think the point about, John Paul, you made about the students being paralegals. And so it's interesting for them to know about the appellate process, but they don't get to engage with it too often. I think that's very important from that perspective, for a paralegal perspective, or for a law student's perspective, or a lawyer who just does trials, to understand the appellate process, because everything you say in court is transcribed. Everything is recorded, and its appeals are based on the court of record. So you may be adjourning something and waiving delay, and that delay waiver may lose someone in a delay argument under Section 11B of the Charter of Rights of Freedom down the road. And if you don't understand how your communication in court it is recorded, like its impact, you may, like it's like a snowball effect, you may be contributing. You are always contributing actually to potential of being reviewed by an appellate court later on. And your words could contribute to either the success. It could be one of three things. It could be nothing, it could be success, or it could be possible failure on an appeal. So it is important to understand the power of your words on a record. You'll see some lawyers in court or some advocates like being emphatic and using their, like just being very loud. And volume doesn't come out on a transcript, so words do. So I would impart the importance of being very mindful of what you're communicating in court and understanding the importance of all of that, because it could impact a client later on, it could impact you later on. So I always respect the process. And thank you, John Paul, for having me, and thank you everyone who's listened for listening.
Perfect. Thank you, Jessica. And the other thing with the transcripts is if you use the filler words, they show up and you're like, I don't realize I say that much, but it picks up everything, right? Because you got to transcribe it. So thanks again, Jessica, for sharing all that valuable insight. And thanks for everyone for tuning in today. And certainly for anyone watching later on, I mean, there's a lot of information here. So appreciated you for imparting all that wisdom with us, and wish you all the best and the firm all the best as they continue that transformation there, and all the best to everyone there. Take care.
Thank you, John Paul. Good luck to everyone on their exams tomorrow. Take care.